presentation and the next, you will see excerpts from a trial of a speeding case. The prosecutor represents the state. Mr. Law represents himself. During argument and testimony, objections will be made and the judge will rule on them. I will discuss these rulings as we go. The participants in this trial are the judge, the prosecutor, Mr. Law, and Officer Best. Ready?
The court calls the State of Texas versus Scott Law for the offense of speeding. Are both sides ready for opening argument?
The state is ready, Your Honor.
I guess so.
Mr. Law, would you please stand? Thank you. Sir, you will need to stand each time you address the court. Do you understand?
Yes, sir.
You may be seated.
All objections or arguments to the court should be made only by the attorneys or the defendant. They should stand and always make their objections calmly and clearly. If a judge does not control the courtroom, one side or the other will, and justice goes looking.
Ms. Prosecutor, you may make your opening remarks.
May it please the court, Mr. Law, ladies and gentlemen of the jury. Today's case involves speeding, an offense that affects us all. Mr. Law was clocked going 68 miles per hour in a 45 mile per hour zone. And Officer Best will testify to getting a radar reading, giving Mr. Law a citation, and his other observations. Pretty simple facts. But the most important fact is that you must find the defendant guilty. He is guilty. Just look.
I object. She's telling them I'm guilty and there hasn't even been any evidence presented yet. What happened to innocent until proven guilty, Ms. Prosecutor?
Sustained. Ms. Prosecutor, limit your remarks to proper opening comments. Mr. Law, you should not direct any comments to the prosecutor.
Although the opening statement or argument is clearly meant to be persuasive, it should also be limited to proper topics. Those include discussions of what the parties expect the testimony to be, as well as relevant law and general matters. Although no rule or statute addresses this issue, the basic fairness at the defendant's objection clearly merits the court's ruling. Objections must be made to the court. Don't let the parties argue with each other. Watch carefully. I'll talk with you later.
Mr. Law, do you wish to make an opening statement?
Yes, Your Honor. I was there. I wasn't speeding. The cop's a big liar. Heck, everyone in town knows...
Objection. The defendant is testifying, not proper argument.
Sustained. Mr. Law, limit your comments to what you expect the evidence to show.
I wasn't stopped because I was speeding. There was another motive here. Watch. Just watch. It's a big frame-up.
Arguments are not evidence. The parties should not state their opinions. Evidence comes in through witnesses. In order to testify, a witness must take an oath. If opening statements get out of control, the trial is likely to follow.
Ms. Prosecutor, please call your first witness.
Your Honor, the state calls Officer Best. If it please the court, we would request that the rule, that is, the exclusion of witnesses from the courtroom, be imposed. All witnesses should be sworn and given instruction not to listen to other witnesses' testimony or to discuss their testimony with anyone except the attorneys or self-represented defendant. Exclusions can be made for experts if the court finds their testimony would not be influenced by hearing other testimony. A victim can only be excluded if the party requesting that the rule be invoked establishes that the victim will also be a witness and that their testimony would be influenced. The defendants themselves cannot be excluded.
Everyone who knows him or herself to be a witness in this trial, please come forward. Ms. Prosecutor, Mr. Law, are Mrs. Law and Officer Best the only witnesses you intend to call?
Yes, Your Honor.
Yes, Your Honor.
Raise your right hands. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Yes.
Ladies and gentlemen, The rule has been invoked. The rule means witnesses who are not parties to the trial must remain outside the hearing of the courtroom at all times while testimony is being heard, except when testifying or until they are discharged. If you're a witness, you must stay close enough so that you may be reached when needed. You must not discuss this case among yourselves or allow it to be discussed in your presence, except in the presence of attorneys or under orders of the court. You must not read or watch any news reports, commentary, or correspondence on the testimony of the case while under the rule. If you will, please wait outside until you are called.
Each and every witness should be sworn in front of a jury. Under Rule 603, a witness who has not taken the oath is not competent to testify.
Officer Best, please take the stand. You may be seated.
Officer Best, please introduce yourself to the jury.
My name is Donald Bess. I'm a peace officer here with the Midway Police Department. I've been an officer of the law here for the past 14 years.
Have you received any training as a peace officer?
Yes, ma'am. I spent 14 weeks in the Midway Police Academy, and in addition...
Objection. The officer's training doesn't matter.
Your Honor, we're seeking to establish his qualifications.
Overruled.
Evidence must be relevant to an issue at trial. It must be related. Since this is a traffic case, the officer's training in traffic enforcement is related, as introductory information about witnesses is generally considered relevant. When ruling on objections, always clearly state whether the objection is sustained or overruled.
Officer, you may continue your answer.
I've also completed numerous continuing education courses in law enforcement.
Starting at the beginning and continuing to the very end, describe your interaction with the defendant, Mr. Law.
Sure, on March 1st of last year, I was on the afternoon shift working radar on Farm to Market Road 5050. I saw an approaching Pontiac Firebird. I turned the laser-derived radar onto the vehicle and...
Objection. The witness is just going on. I won't even have the chance to object. Isn't the prosecutor supposed to ask questions?
Sustained.
In trials, the testimony must proceed by question and answer. This provides an opportunity for the other side to object and for the court to rule. This doesn't mean that the witnesses can't give long answers. However, witnesses should not be able to move from topic to topic and event to event without being questioned. This objection is usually referred to as narrative response. Officer Best, what did you do when the 1997 Firebird came to a halt?
Well, in 1983, one of my fellow officers was shot in the face by a driver of one of these muscle cars. He bled on the side of the road for over 20 minutes.
Objection. That's not what she asked him about.
Sustained. Officer Best, please limit your responses to the questions asked.
Should the jury be able to consider that shooting stuff?
Mr. Law, you need to make your objections statements or requests, not questions.
Why object to him talking about some killing in the early 80s? I also asked the court to tell the jury that it was not fair to have talked about that.
Objection sustained. I will instruct the jury to disregard the officer's last answer.
Remember, you don't advise the parties. You rule on objections. The testimony must be in response to the questions. The officer's answer was not a response to the question asked. So the proper objection is unresponsive. If inadmissible evidence does get in front of a jury, such as the irrelevant testimony given here, it is also permissible, on request by a party, to instruct the jury to disregard the improperly presented evidence. What did you do as you approached the Firebird?
I loosened my weapon in the holster and I checked the back seat of the vehicle on the way to the window.
Why?
I object again. Not relevant.
Sustained.
The previous story by Officer Best is now more relevant in explaining the officer's procedures. However, under Rule 403, the court must balance the relevance against any danger of unfair prejudice. There is nothing this defendant did that indicates he posed a threat, and to imply that could unfairly prejudice the jury's view of him. The danger of this unfair prejudice outweighs the probative value of explaining the officer's procedures. Now, if the defendant made an issue of the appropriateness of the officer's actions, the balance could shift, and the story of the slain officer could become relevant. Now, Officer Best, when the defendant gave you his driver's license, you took down the information from it, you put it on the citation, you compared the photo on the license to the driver, and you explained the citation to him. Isn't that correct?
Objection! The prosecutor is leading the witness.
Sustained.
During direct examination, the questioning party shouldn't lead or suggest the answer to the witness. This can be difficult to identify, but questions that are actually thinly disguised testimony by the questioner shouldn't be allowed. Rule 611C controls leading questions. Questions ending in rhetorical flourishes like, "Isn't that correct?" or prefaces like, "Isn't it true that?" are easily identified as leading questions. Leading questions are perfectly okay on cross-examination or when questioning adverse witnesses on direct examination. However, leading question objections should be sustained during direct examination of presumptively cooperative witnesses. What was Mr. Law's date of birth?
I don't remember right now, but if I could see the citation, it could refresh my memory.
May I approach the witness, Your Honor?
You may.
His date of birth is May 25th, 1968.
So he is over 17 years of age.
Objection! She's leading, and a witness can't review stuff when he's testifying.
Ms. Prosecutor, do you have a response?
Just developing testimony, Your Honor. Refreshing memory is proper under Rule 612.
Objection overruled.
Leading questions can be allowed for technical issues that develop testimony on topics like age, jurisdiction, and employment. Leading questions concerning issues in contention or dispute, however, should not be allowed. As to refreshing recollections, witnesses can review writings before or during their testimony. Once a document is used to refresh a witness's memory, the side using the document must allow inspection by the opposing party.
Ms. Prosecutor, has Mr. Law been provided a copy of the ticket?
Yes, Your Honor. And I am showing him what I just handed the witness. Officer Best, how does the radar work?
Well, the unit is calibrated by the use of a...
Objection! The officer is not a scientist and not an expert in radar.
Sustained. Ms. Prosecutor, you have not qualified the witness as an expert.
Officer Best, have you received any training in the use of radar?
Yes, ma'am. I was initially trained at the DPS Academy. There we spent over 20 hours in the science behind radar. In addition, I've attended 3 continuing education programs in radar. There was one in Indianapolis, Indiana, where we spent 32 hours in the science behind the radar, its construction, use, and maintenance.
So you can tell me how it works.
Absolutely.
Objection! The officer is still not a scientist, and you can't be an expert unless you're a scientist.
Overruled.
This brings up one of the more difficult areas of the law of evidence, expert testimony. Witnesses must testify to what they saw, heard, know, etc. Opinions are usually out of bounds. The exceptions are experts. Experts are persons with scientific, technological, or other specialized knowledge. They must be qualified by knowledge, skill, experience, training, or education. The expertise must match the testimony. Establishing the witness's expertise and the qualified knowledge, skills, training, or education is called predicate. The predicate must be established before the witness can testify as an expert. That is why the judge sustained the earlier objection. The judge overruled the second objection because the officer's training qualifies him to give expert testimony, even without academic degrees or qualifications. The expert must simply have some knowledge not possessed by the average individual. How do you make sure the radar is working?
Well, you test it with a special tuning fork. I do this at the beginning and the end of every shift.
And how long has this been your habit?
6 years.
Did you perform the test on the day you wrote Mr. Law the speeding citation?
I don't recall, but...
Objection! He can't say if he can't recall.
Response, Ms. Prosecutor?
The testimony concerns personal habit. It is admissible as such under Rule 406.
Objection overruled. Officer?
I'm pretty sure I did test it. I do it every shift.
The prosecutor was correct. Rule 406 allows testimony as to a person's habit or an organization's routine practice. The habit or routine practice is relevant to whether the act took place, regardless of the general rule of personal knowledge. So, Officer Best, why do you think Mr. Law decided to break the speed limit?
He didn't say, but my guess is that...
Objection! The officer can't guess or speculate on that.
Sustained.
Witnesses can only testify to what they did or observed. Expert witness testimony is the exception discussed earlier. Regular witnesses are usually only competent to testify to those things for which they possess personal knowledge. Speculation, guessing, and similar assumptions are objectionable and inadmissible. Welcome back. We left off with the witness being passed from the prosecution to the defense.
Okay, Officer Best, you get bonuses for making your quota of speeding tickets, don't you?
That is not true. There are no bonuses and there are no quotas.
In fact, there is a bonus system and there is a mass conspiracy.
No, sir.
Of course. You're a part of it. Liar, cheat, admit it. You are under oath. Admit the conspiracy.
Objection. Badgering the witness.
Sustained.
As we discussed earlier, the court must keep control of the parties. The court is specifically charged with protecting the witness from harassment and undue embarrassment. Difficult but relevant questions should be allowed. However, witnesses should not be subject to the bad overacting one sees in some courtroom movies. Repeatedly asking the same question, ridicule, and undue sarcasm are not appropriate.
Continue, Mr. Law.
So what is your daily quota?
There are no citation quotas.
What is your weekly quota?
Asked and answered, Your Honor.
Sustained.
Give the party some leeway, but don't allow needless repetition of questions when there's been an objection.
Officer Best, doesn't your salary paid out of the police department budget come from honest taxpayers like myself?
I don't know the source of the police department budget.
I asked the court to take judicial notice that the city police department is funded by the city, which in turn raises its funds through taxation.
Any objections by the state?
No.
The jury is instructed that the police department is funded by the city, who in turn raises money through taxation. You may accept this as proof or reject it.
Be very careful when you're asked to take judicial notice. It should only be taken of matters that are indisputable. If it can be found in an almanac or official record, if it is something everyone knows, then judicial notice may be taken. The judge should inform the jury that a fact is proven, should they choose to accept it, by the court taking notice. The rules also specifically require the court to hear both sides before taking notice.
Officer Best, when you approached my car, my wife told you I wasn't speeding, right?
Objection. Hearsay.
Sustained.
Now we have entered another area in the rules of evidence that can be difficult. Hearsay. First, a hearsay statement is one that is offered into evidence to prove the truth of the matter asserted. Next, matter asserted means matters explicitly asserted or implied if the probative value of the statement offered comes from the declarant's belief of the statement. If an individual commits an act by speaking words, the probative value of the statement is that it was made, not that the declarant believed it was true. As an example, a person in a crowded room shouting "fire" is not hearsay if the evidence admitted shows he endangered the public. The statement is hearsay if it was introduced to prove that there was, in fact, a fire. Allowing hearsay would allow a witness's statement to come before the jury as evidence without the witness being sworn in or subject to cross-examination.
Your Honor, I would like to introduce this sworn affidavit from my wife.
Objection. Written statements are subject to the hearsay rule.
That's correct. Sustained.
My wife called you a big old jackbooted slug, didn't she?
Objection. Hearsay.
Overruled. Officer?
Yes, I believe so.
Oral and written statements made out of the court are hearsay, even if sworn to. This last question doesn't really go to the truth of the matter asserted, but rather to the declarant's state of mind. This may not be relevant, but that wasn't the objection. She is identified as a witness, and the judge chose to allow it.
Officer, didn't you say at the scene that I was getting a ticket for my attitude, whether I was speeding or not?
Hearsay.
Overruled. Officer, you may answer the question.
I may have said it to keep you from arguing.
Although this may fit the description of hearsay, it was a prior statement by the witness. Not every statement by a witness is admissible, but the exception is very broad. Any statement that is inconsistent with the witness's testimony is admissible. Any statement dealing with fabrication or motive, as is the case here, is admissible. A statement by a witness identifying a person is also admissible. Prior consistent statements made by a witness are generally not admissible unless prior inconsistent statements are also admitted.
No more questions.
Any redirect questions, Ms. Prosecutor?
Just a couple, thank you, Your Honor. Officer Best, did Mr. Law say anything about whether he was speeding?
Well, at first he denied it, and then...
Objection. Hearsay.
Admission by party opponent, Your Honor.
Overruled. You may continue your answer.
Then he said, speeding or not, I'll see you in court, jerk.
Admissions made by a party are any statements that they made out of court, regardless of whether the party has testified or will testify. Admissions made by a party also include statements adopted by a party. Adoption is when a statement is made in a witness's presence in a way in which the witness appears to agree with the statement. This exception makes confessions admissible.
Officer Best, you had an observer with you from the local high school on this date.
Yes, his name was David Young. He was 18 at the time.
Did he say anything when you first put the radar on Mr. Law's car?
Yes. He yelled, look at that guy. He's flying down the road.
Objection. Hearsay.
Present sense impression, Your Honor.
Overruled.
When you returned to the vehicle, did he say anything?
Yes. He was very flushed and worked up at the confrontation in Mr. Law's vehicle, and he said...
Objection. Hearsay.
Excited utterance, Your Honor.
Overruled.
He said, that guy was so rude and you were so nice. Now I've changed my mind. I could never be a cop. I would have shot him.
Those were two examples of exceptions to the hearsay rule: present sense impression and excited utterance. A statement describing or explaining an event as it happened or as it was perceived or immediately thereafter is admissible as a present sense impression. An example is the young man pointing out the speeding vehicle as he sees it speed by. Present sense impressions are admissible even though they are hearsay. An excited utterance is a statement, 1, related to a startling event or condition, 2, made while the declarant is under the stress of excitement, and 3, caused by the event. These statements are also hearsay, but admissible as excited utterances. The declarant must be excited or stressed. The 18-year-old riding along qualified. The officer might not. Both of these exceptions to the hearsay rule are created because something about the statement argues that it would not have been made if it were not true. There are many other exceptions to hearsay, including public records, records of regularly conducted activity, family records, and statements made for medical treatment. Each exception is contained in Rules 803 and 804. Each must be established by proper predicate of proof before the statement is admissible.
No further questions, Your Honor.
Mr. Law, any more questions?
No.
Officer Best, you're excused. Any further witnesses for the state?
No, Your Honor. The state rests.
Mr. Law, do you have a witness?
Your Honor, my wife has the privilege not to testify, right?
Ladies and gentlemen of the jury, I'm going to ask you to step out.
There are issues that need to be addressed by the court that the jury shouldn't hear. For example, the invocation of privileges. Other examples are protracted objections or offers of proof, which are a record of items that the court has held are not admissible. A spouse has a right to refuse to testify in a criminal case against his or her spouse unless the defendant is accused of a crime against the spouse or member of the household. Communications between spouses is also privileged. Either spouse may invoke this privilege.
My wife will not testify.
Ordinarily, your wife would have to invoke the privilege, but since the prosecutor has not called her, all you have to do is not call her.
Also, I do not want to testify. I invoke my Fifth Amendment rights.
Thank you, Mr. Law. You have the absolute right to do that. And the jury will be instructed to not consider the fact that you have not testified in any way. Is there anything else?
Yes. I have a letter here from this officer's captain reprimanding him for being rude to a citizen back in 1997.
Objection! This document has not been authenticated and is not relevant under Rule 404B. And finally, it is hearsay.
Sustained. Anything else?
No.
Recall the jury.
The two rules referred to are both important. Any document or item must be authenticated by a witness or affidavit. There must be sworn testimony or admissible hearsay in the form of an affidavit establishing that the writing or item in evidence is what it is purported to be. The letter was not authenticated without testimony. Rule 404B is important because, except in limited circumstances, proof of prior conduct of a person is not relevant to prove that he acted in the same way in the instance at trial. In other words, proof that the officer acted rudely once in the past is not relevant to whether he acted rudely in this instance. It can become admissible only if it is introduced to show motives of the actors, plans the actors created, a lack of mistake in committing the acts, or similar grounds listed in the rule. Applying this rule depends on determining why the evidence is being offered. Generally, previous bad acts are introduced to show that if the actor did this once, he is more likely to have done the same thing in the instance at issue in trial. Such testimony or evidence is declared by the rules of evidence as irrelevant. Now we are going to closing arguments. Remember that in actual trials, you must read the jury instructions to the jury before an argument.
Are both of you ready for closing argument?
Yes, Your Honor.
Yes, Your Honor.
The prosecutor goes both first and last, but both sides have equal time.
May it please the court, Mr. Law. Ladies and gentlemen, without speeding laws, we are all at risk. For our own protection and for the protection of our children, we have limits. Mr. Law broke those limits, and Officer Best caught him. That made Mr. Law angry, but it doesn't make him not guilty. Who was rude to whom doesn't matter. David Young said it best. Look at that guy flying down the road. Now, if Mr. Law wasn't speeding, he would have called his wife to the stand.
Objection! She had a privilege not to testify.
Sustained. The jury is instructed to disregard that statement.
The parties cannot comment on witnesses who do not testify due to the invocation of privilege.
Officer Best did his job. He caught the speeder. I did my job. I prosecuted the speeder. Now you do your job and find him guilty. Thank you.
Mr. Law, you may close.
Ladies and gentlemen of the jury, if I was guilty, why did this prosecutor offer me defensive driving?
Objection! That was not in testimony and is not relevant under Rule 410.
Sustained. The jury is instructed to disregard that statement.
Plea bargain offers, offers to compromise, and subsequent remedial measures are all specifically prohibited.
This systematic harassment of good citizens like yourselves in order to line the greedy pockets of our city's government has to stop. The question you want to ask yourself is, do you trust these bureaucrats? Well, do ya? Not guilty. Power to the people.
We waive further argument.
Ladies and gentlemen of the jury, you may retire to consider your verdict.
There are a number of rules and exceptions we didn't cover here, but there is no substitute for reading the rules of evidence. Also, as a trial judge, you should listen carefully to objections and invite response if you're not sure. But, equally important, make a firm decision and follow it. You are the judge. Don't be worried if someone stands up and says, "I object."